Okay, good afternoon, everybody. Ryan Wozniak here at Peninsula, and we are settling down for our weekly Facebook Live session where I am here to field and answer any questions that any of you in attendance today may have for us or me specifically about your business, and in particular, how the COVID-19 pandemic is impacting your business. And we have a full hour today, and this is, I think, our fourth or fifth session now of these weekly discussions. And for those of you who have not attended before, this is more or less a fireside chat style of format. So you're welcome to ask me any questions that you may have, and they come up on the left side of my screen here, and I'll read out the question and answer it as best I can based on the information given to me. And we are here to cover literally any HR related issues that are impacting your business. Okay. And by way of background, for those of you who haven't come before, I am the Vice President of Legal and Operations at Peninsula Canada. And prior to joining Peninsula in July of 2018, I was a commercial litigator for 12 years in Toronto, and I practiced um, exclusively in the area of commercial disputes and employment law. So without further ado, please feel free to start posting your questions on the board, and I will, as I said, read them out and answer them as best I can. And as always, I'm really glad to have everybody here today because I find these sessions extremely productive and extremely valuable, and I hope very helpful for all of you who are watching. Okay, first question I have is if I cannot find PPE, so personal protective equipment, can I ask my staff to source it and offer them or offer to reimburse it? Um, yeah, I think that's a proactive and sensible solution, provided that you are confident in the quality of the PPE and that the equipment that the employee is sourcing is going to be reasonably safe in the circumstances. So, for example, people aren't buying homemade masks that might not meet certain um, health and safety specifications for the type of equipment that you need. But certainly. Okay, another question I have is I have laid staff off. I'm now needing to recall some staff. Can I refuse to bring back staff I know are not taking social distancing precautions? Great question. I think that you can require staff that you're recalling to work to demonstrate, reasonably demonstrate, or provide some form of reasonable evidence that they have taken certain precautions to ensure that they're not endangering your workplace or their coworkers when they come back to work. So, for example, an employee might have an employee sign an acknowledgement form that the employee has been honoring or complying with social distancing requirements, that they are not demonstrating or have not demonstrated symptoms for the past 14 days consistent with COVID-19, and that they have not knowingly interacted or interact with someone they believe or have reasonable grounds to believe may be infected or have been exposed to somebody else who's infected. I think that's a reasonable starting point. Medical clearance certificates are an option, although I don't know how practical those can be in certain situations because getting a doctor's note right now is not the easiest thing in the world. And obviously, if someone has been sick, has exhibited symptoms, or may even have been infected, I think as an employer, you'd be wise to get a clearance certificate confirming that that individual is no longer symptomatic, that they have recovered, and that they're able to safely return to work. Okay? Okay, so we have, I believe, 8 people here now. Hopefully that number will grow. But if you have more questions, please fire away. As I said, we have an hour every week, so don't be shy. Perhaps if any of you out there are wondering what you do or what you should be doing if you have staff that you've laid off that you don't want to bring back, whose employment you want to permanently end, how are you going to do that? That's a very um, relevant conversation now, one unfortunately that's coming up a lot. It's an unfortunate reality, but one that many of us are facing right now. We can talk a little bit about that today if you like. Um, Extending layoffs or talking about when a layoff becomes too long and becomes a termination is very relevant right now. So, again, happy to discuss all of those issues with you today. If anyone has any questions. Looking at the question feed here. Okay, up to 10 people. If anybody who's just joined us, again, please feel free to ask any questions that you may have regarding HR challenges that you've been facing in light of the COVID pandemic and how it's affecting your business or decisions that you may be looking to make or any general specific queries you may have regarding your own HR needs. That's what we're here to do today. Again, we're doing a fireside chat. This is very informal. It's open. The floor is completely open to all of you in attendance. Do not be shy. Okay, great. We have another question. How do you manage staff that continue to get doctor's notes to stay off work due to pandemic-related issues, but who are not actually sick? Great question. And this is, as we know, a challenge even when we're not in a pandemic situation. Employees who often furnish medical notes that are short on information and short on detail, it makes it difficult to accommodate them. Um, I think that in these types of situations, one option is to retain a third party um, assessor, and there's services out there, service providers that do this, who will evaluate the veracity and credibility of the note that you've received from the employee's treatment provider and provide a second opinion. Again, it boils down to reasonableness as well. You can always ask the employee for permission to contact the doctor or their doctor to seek clarification as to why um, they can't work due to pandemic related issues. I mean, what does that mean? I have no problem with an employer going back to an employee or doctor saying, well, this doesn't provide me with sufficient clarity. Are you sick? What is a pandemic related issue? Okay. I think a lot of the times this is just people who are scared and don't want to go back to work. And that we often talk about that issue in the context of unsafe work refusals, employees refusing to perform work because they feel it's unsafe. And they might say, well, you know what? I don't want to go back to work because leaving my house is unsafe and going out in the real world again is unsafe. I could get sick and perish. And I don't think that's a sufficient answer. I think if someone is legitimately ill, maybe they've been infected or exhibiting symptoms, I think they're perfectly justified in seeking some isolation time or self-isolation time. It would be wise to do that. But someone who's on the treadmill should be challenged, and an employer should be proactive, seek further clarification from the employee and from the medical providers. And if they get stonewalled, reach out to perhaps a third party assessor and have someone else review the evidence and find out what exactly is going on. And if the person's not sick and they're fabricating reasons or trying to find excuses not to come to work, then depending on the facts or depending where you are in that conversation, it could constitute a job abandonment. An employer could be in a position to sever the employee's relationship with the employer at no cost to the employer. Okay. Obviously, it's fact specific, but generally speaking, as employer, you have options. Okay, just as you would in a normal illness situation. What happens if there's another surge and we have to shut down again? Can we lay off in the same way? Would the layoff period begin again, or would it be added to the previous weeks? It's a rolling period, so you would start if you lay somebody off again each time. It doesn't reset the clock. Once you've initiated a layoff, it's a rolling 52-week period. Well, it depends on which province you're in. So, for example, in Ontario, or let's take British Columbia. Okay, British Columbia, you can place an employee, provided you have a contractual right to do so, an employee on temporary layoff for no more than 13 weeks in a 20-week period, although the government has just increased that to 16 weeks if the reason for the layoff is COVID related and the employee consents. But in that situation, you would have to let that first 20-week period roll out, and then you could either recall that employee and take them off layoff and continue to employ them. But you can't, otherwise, an employer could just recall someone, start it again, recall someone, start it again, and continuously lay them off in perpetuity. Okay, so you have to monitor that first. And practically speaking, and at that point, who knows where we'll be in 30 weeks. Now, the challenge a lot of employers are going to have is what happens if the lockdowns in certain industries extend beyond the layoff limit prescribed by statute. So what if the industry shutdown goes on for 20 weeks and you're up against a 16-week lockdown cap on statute? What is that going to do? Is it force you into a deemed termination situation? See what the government does about that. I imagine they take measures to try and protect businesses from basically being forced to pay a bunch of people termination pay when they might actually want to bring them back to work in a couple of weeks anyway. Okay. Okay, just looking here, we've got, I see 13 people here now. Great. For those of you who've joined us, again, feel free to ask questions. We're here for another 45 minutes, so don't be shy. As I said earlier, at the beginning of this session, you can ask us any questions that you may have regarding your HR issues or your any pandemic or COVID-19 related challenges you may be experiencing. And we'll talk about them here in this little fireside chat that we do every Wednesday. Again, I mentioned this earlier, if anyone talking a lot about recalling people, and I notice a lot of small businesses I've been talking to are running into employee objections, people refusing to come back to work because they feel that it's unsafe. And what does that mean? And as an employer, what rights do I have to combat that, or how do I combat that without running afoul of health and safety legislation? And what do I do? What do I tell an employee in that situation? And what happens if I disagree with the employee? There is a process for that. But how do I assess what's reasonable? Which is always the biggest challenge for employers. Employees will say myriad things when they feel nervous or upset. But it boils down to reasonableness legally, and we can talk a little bit about what that means. Next question. We have introduced new working from home policies and some staff are not happy with them and refuse to sign new contracts. Are they quitting or will our business be held liable? Okay, well, these types of rollouts are factual, but generally speaking, when you introduce new documentation to staff, it's interesting. The questioner says policies and then contracts. So generally, I'll start with contracts. If you are introducing employment terms to an employee that are more restrictive than the terms they're currently working under, so as is often the case, an employer will have employees working with no written contracts. In that situation, the law implies a bunch of terms, the most common one being the obligation to provide common law reasonable notice of termination if the employee is dismissed without cause. And provincial employment standards legislation will effectively imply or read in a bunch of minimum standards into the contracts. You can't make someone work longer than a certain number of hours, they'll pay them the overtime, minimum wage requirements, and weekly hours of work restrictions and the like. So let's say an employee is working under that type of situation or under those types of implied terms. Employer says, well, I'd like to now introduce a contract. And almost invariably, or invariably, I should say, which is really the truth, the new contract that I'm introducing is going to significantly restrict some or all of the employees' existing implied rights. And contracts will always contain or should contain a clause limiting the termination pay that an employee will receive in a without cause termination situation. So the law requires, if you're going to do that, that the employer provide some kind of consideration to the employee. You're taking, in other words, employer is going to take something away from the employee. Employer has to give something back. Signing bonus, something in law called the peppercorn theory, okay, that some crafty judges came up many years ago with, and basically says peppercorn could be sufficient consideration. Who's ever going to do that? But the point is, it can be anything. Maybe a paid vacation day, a small signing bonus, or maybe you restructure an employee's role, give them a slight salary increase and some different job duties or different title that they may have been looking for. And that can help overcome the hurdle of introducing new contractual terms, which may not be popular with staff, because keen staff will look at it and say, "Oh, what are you making me sign now? What are all these rights?" And maybe they go to a lawyer. So there's a little bit of finesse involved, along with some complying with some legal technicalities. Now, when we talk about introducing new policies, that's a little bit different because policies tend to be more sweeping. I mean, obviously, if you roll out a policy that says everyone who's going to be dismissed without cause gets the statutory minimum, and try and sneak that in, that's not going to go over very well and probably wouldn't be enforceable. But when we talk about things like absence management policies, working from home policies, especially policies that you need to respond to a pandemic situation, which are a best practice, which most judges and lawyers would look at and say, that's really good that you're doing that. You're managing the situation, you're being transparent with your staff, you're setting expectations, you're doing it consistently, great. Employees might push back. Again, the best way to do that is to have an actual clause in each employee's written employment contract along the lines of the employee hereby understands and agrees that the employer or the employee will be bound by the employer's policies and procedures as implemented from time to time as the needs of the business evolve. And furthermore, the employee understands and agrees that the employer may change those policies from time to time as the employer deems necessary based on the circumstances of the business, and the employee agrees that that does not constitute a constructive dismissal. And so it's really a two-pronged attack, and that's the best way to do it. And then, if an employee refuses to formally sign off on it, you could take the position that, well, you've given them notice. This is a company-wide policy that's applied to everybody. You will enforce the terms. And again, as long as they're not fundamental changes, like stripping someone's salary or something like that, I think that's a stretch. But if you're talking about implementing a working from home policy, then with reasonable terms that you're going to enforce, I guess I'd be open to employees say, tell you what, I'm objecting to those terms. I've been constructively dismissed. I'm going to walk out the door. I think that'd be a silly move. I think you would try to enforce the terms, and the employees push back and say, well, I'm not going to follow these terms because I think I've been constructively dismissed. Well, they haven't sued. they haven't quit and sued, and they've effectively, impliedly carried on their jobs and let these terms go into play, you got a good case as an employer to say, you know what, you're bound by those terms now. I want you to follow them. Okay, it's a tricky one. Okay, but the key is to always be fair and transparent, and make sure you have those contracts in place that give you that flexibility in your employee management. Um, Next question. So that was a long answer. I'm a bit behind now. Um, Next question I have is, do employers still need to pay termination pay if we choose to extend a temporary layoff past 120 days if we can prove that revenue is down due to the pandemic? So imagine this person's in Alberta, referencing 120 days. If you, as an employer, if you surpass, the general rule is if you surpass the period of layoff, permissible layoff under the applicable employment standards legislation in Alberta, it's 120 days now. It's been extended to 100 days during the pandemic, and it's what's called a deemed termination. Okay, in a deemed termination situation, um, the statute basically requires that the employer pay the employee termination and severance pay. It's deemed by statute to be a dismissal um, with without cause, essentially. Now, you can, during the layoff, agree to extend the layoff period, but you would have to get the um, agreement of the employee to pay the employee wages, so effectively become a paid layoff. Okay, um, and that gets very costly. So you can avoid termination, but if you're going to extend it beyond that point, an unpaid layoff, which is the statutory period, is an unpaid layoff. If you want to extend it beyond that period, you basically have to get the employee to agree that they'll stay on paid layoff until you're ready to bring them back. Okay, in which case you might be better off. You're going to be in a deemed termination situation anyway. It might be best to just sever the employment, especially if you have an employment contract that limits their termination pay to the stat minimums. Then you could avail yourself of that clause, exit the employee from the business, and you probably get a cost saving if you do it that way. Okay, I just want to back up and make sure I've answered that question. And pardon me, the last point I'll mention is revenue when it comes to layoffs is statutory statutory rules regarding temporary layoffs. Revenue, government doesn't cut you a break if revenue's at a certain level. That applies to the government benefits, and probably the wage subsidy might be where that query is stemming from. Okay. Um, Next question I have: how many attempts do we need to make to recall staff before we can sever the relationship? There's no set amount. There's no, once it's 3 times, you're good. It's about how many reasonable attempts and the way in which you do it that really matters. So, for example, if you send a recall letter to an employee saying, okay, we're ready to bring you back to work. And if you're in Alberta, by the way, in BC and Ontario, there's no statutory recall notice requirement in the non-unionized setting. In Alberta, if you want to recall an employee from temporary layoff, you have to give them 7 days notice under the Act. And you have to serve it, and the employee has to come back. You have to give them notice, sorry, under the Act. It has to be written. The employee has to come back within 7 days. And if they don't, you're actually, as an employer, able to effectively treat that as a job abandonment and sever the employment relationship at no cost. But as a practical matter, what you want to do is send a clear uh, recall notice letter to employees you want to bring back, and be specific. We're bringing you back under these terms and conditions. We'd like you to start on this date. Make sure that you serve it or deliver it in a way that's going to get to the employee. Email is one way. You might want to consider courier or registered mail, and make sure you follow up and get a response from the employee. Okay, and address any concerns they might have. You might want to recall them in 4 days, but they might need time to get arranged for childcare, or maybe they're taking care of a dependent, or maybe there are other obstacles that they're facing in their lives. Maybe they're ill, demonstrating symptoms, they need time to get better. You have to make sure you factor those in because your request has to be reasonable. If someone's been infected with COVID, and you say, okay, I want you back to work on Monday, or they're exhibiting symptoms, you say, I don't care. Well, yeah, they're going to say, I can't get back in. And you're going to say, okay, well, how about in 2 weeks or another week, or you get a medical clearance certificate, or they need a week to find they're going to move a parent in to look after the kids so they go back to work. So they have some flexibility. If you're not fair with them, then it's really hard to say, oh, look, I asked you to be here on Monday. You didn't show up. I know you got kids and you have no childcare. Too bad. You know, I'm treating this as a job abandonment. You're done. But if you do all of those things and you send recall notices to your staff and you give them a reasonable amount of time to respond, you're totally transparent and clear about what the expectations are, and either you don't hear back and you follow up multiple times, and once is probably not going to do it, but you follow up a few times and you just completely get stonewalled, then you're in a position at that point to say, you know what, I'm going to treat this as a job abandonment. I've reached out to you. I've made every effort to bring you back. I haven't heard from you. I'll assume you're not interested in coming back, and I'll end the relationship. Okay. So again, it's not a fixed number of times. It's how you do it, and be consistent, be clear, be frequent, and follow up. Those are Do all those things, and you'll be in a good position as an employer. When calling staff back to work, but someone when calling staff back to work, but someone specific job duties have changed due to how the business is running now due to the pandemic, if they refuse to come back to work to their under their new job, basically under the new job duties, what rights does an employer have? Can they terminate without termination pay, or what would the process be in this situation? Okay, so a plaintiff employee, a plaintiff employment lawyer will tell you that, well, any employment lawyer, I guess, probably more, a plaintiff employment lawyer will tell you in more aggressive terms, will tell you that technically speaking, that could be a constructive dismissal. Okay, if you're had someone pre layoff who was a senior manager and had a bunch of responsibilities, and then you're bringing them back to lesser hours, doing fewer jobs, reduction in job title, and significant reduction in pay because you've had to restructure your business, that person could say, those are unilateral fundamental changes to my terms of employment. I'm not happy about it. I'm going to insist on the original terms. And I'm going to take the position that I've been constructively dismissed, and I'm going to go and demand that I either get my full payback, or I'm going to threaten to sue, or I'm going to get a lawyer, and all these horrible things. The reality is that for a lot of people right now, that's a risky move, because as an employer, if you make unilateral fundamental changes, that alone is not enough to allow employees to sue. Employee would actually have to resign to what's called crystallize the breach, and then they would have an actionable case. And if you sue for constructive dismissal and you lose, you get nothing, effectively a deemed resignation. And you might also jeopardize your ability to claim government benefits, because you can't get government benefits if you voluntarily left your job. So it's high stakes poker right now. And how long is it going to take you to sue and collect and settle when courts are effectively ground to a halt? Civil litigation is moving at a snail's pace. Employers are not going to be in a position, nor are they going to want to be in a position to settle quickly. What's the incentive? Take it to trial. I mean, it's going to take months, if not years. So we also have to factor in that employees are under an obligation to mitigate their losses. So without getting into too much detail, a 2008 decision of the Supreme Court of Canada called Evans versus Teamsters Local Number 31, which stands for the proposition that an employee who says they've been constructively dismissed effectively, who's had their job employment terms unilaterally altered by the employer, must nevertheless continue to work under those modified terms while they look for a new job, unless their work environment is unduly hostile or embarrassing. So when you add all those things up and you look at it through the lens of the employee, do I really want to take that gamble? Maybe I should just go back to work on the modified terms, get paid what I'm supposed to be getting paid, as long as it's not horrifically embarrassing or totally unreasonable. You're working 24 hours a day or something like that, which would be illegal anyway. But you get my point. Then I think the expectation person should go back, and if they're not happy, look for something else. Okay. Hope that helps. A bit of a long-winded explanation, but constructive dismissal issues and work refusals can get a bit murky. They're very fact specific, and there's no clear line when it comes to adjudicating these types of claims. It's not like there's a checklist where you go, oh, okay, if you do 1, 2, 3, 4 in every single instance, you will be successful as the employee plaintiff, or you will be successful as the employer defendant. It's very contextual, very fact specific, and all of the precedents that we typically rely on as employment law litigators and practitioners are kind of hanging in the balance right now because they were decided in outside of pandemic conditions, and pandemic conditions change everything. What's reasonable mitigation efforts? What constitute reasonable mitigation efforts when the job market's dead? So a lot of unknowns right now for everyone: employers, employees, lawyers, advisors, politicians, policymakers. So, okay, moving along. Anyone have any more questions? It's 12:30 already. Wow. Lawyers can't talk. I know, but again, here to answer your questions and have a conversation with all of you, as one-sided as it may seem in this format. But I do enjoy doing this, and don't be shy. I noticed that we've got 17 people in the room now, which is great. I think we started with 8. So, um, oh, here's a question. Hmm. New open rules began yesterday, um, but we are not yet comfortable opening. Can an employee take action if we are able to open but aren't? Can they claim dismissal? Interesting question. I um, don't think so, and I'll tell you why. First of all, an employer has the right to lay, well, again, if they have a contractual right to lay somebody off temporarily, they can work with the statutorily prescribed deadlines and layoff periods. So as long as an employer doesn't run afoul of those statutory limits, it's totally open to them, I think, when they want to reopen their business for whatever reasons they may have, whether it's they don't feel they can generate enough cash flow at the moment, or they need time to arrange their affairs or secure financing, or whatever the case may be. All right. And employee might not be happy about it, but I don't think that's grounds to claim constructive dismissal unless your contract perhaps contained a specific recall right that's not being honored. For example, this would be the case in a unionized setting, but in a non-unionized setting, it'd be very rare where I think an individual employment contract would contain specific recall rights, but I could be wrong. And if those rights are breached, employee, I guess, could argue that they've been dismissed. But as long as you're not running foul of the layoff restrictions contained in provincial employment standards legislation, I think you're okay. Next question I have is, now that it has been communicated that the province will not reopen schools, and if we have staff with small children refusing to come back to work, are they forfeiting their jobs? Really great question. And the short answer is probably not. And I'll tell you why, and why I use the word probably. In most cases, no. Um, and I don't know what province you're in, but all provinces, I mean, Alberta and BC and Ontario have all done this, have amended their provincial employment standards legislation to include job protected leaves for people who cannot work due to COVID related reasons. So, quarantine, self isolation, but also childcare obligations. So, I can't go to work. Take an example: a dual income household, both parents are working with small children, and schools are closed, daycare centers are closed, and they can't afford um, childcare, private childcare, a nanny, for example. So one parent has to stay home and look after the children, or maybe they decide to take parents take rotating. I don't say shifts. That's not the right word, but rotating schedules. And that employee could then invoke unpaid statutorily protected leave to look after their family. And while that employee is on that leave, they are entitled to all the protections that they would be entitled to under any other statutory leave. So you can't change the terms of their employment. You can't fire them. You have to bring them back to their position unless the the circumstances of the business change that render that impossible. And so they are protected. It's unpaid protected leave. And that will go on for as long as these emergency orders are in place until the government says otherwise. Okay, so in short, they're not forfeiting their jobs, but they have to invoke the leave, right? So they have to say, I'm taking a job protected statutory leave and now I'm protected. I can't just not show up to work. Okay. Um, so if they have to take child protected leave, does their ROE need to be changed to state as such? I don't know if I don't know off the top of my head what the feds have said about what code you're supposed to put in the ROE for child protected leave, but always a good idea to provide as much information as possible. If you go on the government website and check, it'll probably tell you. I don't know if, again, I don't know off the top of my head. I haven't filled out an ROE in ages, but if you check the government site, there should be um, some clarification, or one of our Peninsula team members can assist you with that if you need help. Okay. Next question. What about when their children center is open, but they do not want to send their child and refuse to work? Okay, so we're going back to the child care issue. Well, that's a little bit different. Um, there's no legal requirement that somebody send their kids to childcare, to daycare, or that they pay for a child care center. I think someone asked me a couple of weeks ago whether they're actually providing the child care to their staff. There's no, I mean, you don't even have to technically send your kid to school um, if you don't want to. But most of us do for obvious reasons. Um, so someone might say, well, I'm going to homeschool my children, or I don't have, or they're not able to go to school, so I have to look after my children. And they might use that as an excuse not to go to work and perhaps continue to collect the CERB. And I haven't, this is obviously a new leave. I haven't seen any litigation or court decisions on those questions about whether or not somebody um, needs, if they get recalled back to work, must, in order to accommodate the employer's request, put their child in some private or public daycare facility in order to do that. Again, I can't say definitively how that would play out. Um, but I think an employee would be tough. I think it'd be tough for an employer to say, you've abandoned your job because you haven't put your child in a daycare facility in order to come back to work because schools are closed. I think that one will be tough. Might be a little different if schools were open, but a little bit tougher. In particular, because we're not entirely clear yet how um, this whole how daycares are going to operate, and what the safety requirements are across the board, and what have you. But I completely understand your frustration. And employers right now I have no doubt, are going to run into this a lot. Employees saying, I don't want to leave the house because it's not safe. Um, and, you know, that is easy in theory for me to talk to you about from a legal standpoint, very challenging on the ground as an employer. What's reasonable? Um, as a fallback, if you're making sure, taking reasonable precautions to ensure that your workplace is safe, I think it's really hard for an employee to say, short of a clear case of a lack of proactivity on the part of employer, social distancing or policies or anything in place, employees, what, you've done nothing, I'm not coming back, it's not safe. Short of that, it's shades of gray, and it's going to be very contextual analysis. Um, but I think the main point for employers to take away is, if you are taking reasonable measures and doing all that you reasonably can in the circumstances to ensure your staff are safe, I think you can be confident in your legal position. Okay. Next question. We have an employee currently on layoff whose contract is set to expire at the end of July. We do not wish to renew the contract. Is it all right to inform them of this now to give them the most time to search for a job? Okay, interesting question. So expire at the end of July. I guess maybe if this is a fixed term employee that you've put on layoff, um, then normally in a fixed term contract, you just let it expire. And the contract ends and it wouldn't be renewed. And because fixed term employees are fixed term, there's generally no notice requirement subject to um, certain requirements in the Employment Standards Act that can require statutory notice um, under the Employment Standards Act in Ontario, for instance, if certain conditions are met. So if the contract, if the person's employed for longer than a year, is one that jumps to mind. So I don't really know what the terms of this contract are. And the other thing to bear in mind is whether there's actual notice provision in the contract. I don't know if this is meant to be independent or dependent contractor or fixed term employee, but if there is a notice provision in the actual contract itself, then it absolutely needs to be honored. And you have to check and see whether it's paid notice as well, because a person may be on layoff now, but if the contract entitles them to termination pay, then you would have to make sure that that's provided. But good that you're thinking about it now and being proactive about it. Well done. Next question is it not reasonable that if they had to in the previous years make arrangements for the summer while school is out, that they would make similar arrangements now? So I think we're talking about childcare. Um, well, if there's been a past practice, sure, while school was out, they would make similar, why they would not make similar arrangements now, except that there's a pandemic. Um, so things are a little bit different. People are a little bit scared. Certainly an argument there um, that people would do that to come back to work. But again, I mean, I don't know what all the facts are behind this scenario. I don't know what um, in particular has happened. The biggest challenge we have right now is the unknown. I absolutely understand where employers are coming from. It's very frustrating. Um, and what we just don't know is what type of latitude adjudicators and perhaps courts are going to give to employees and employers in these situations because it's so novel. All of the historic rules of employee management, case law precedent that's out there is still there, but there's a huge footnote beside all of them right now because this situation is unprecedented for all of us. And judges are probably saying, "Going, gee, what am I going to do if I'm asked to adjudicate some of these cases? What's legal and what's fair?" So, that's a tricky one, and I just think it's tough to force someone to go and send people to childcare facilities amidst the pandemic, but I could be wrong. Okay. In BC, childcare was never ordered closed. Yeah, schools have remained open for essential workers and will further open June 1st. We're now in phase 2 of our reopening plan. Staff still refuse to come to work. Um, how can we refuse to deal with this? Well, again, if parents have children who are going to school and who are going to daycare and they've absolved themselves of the need to be with their children all day has been rectified and they're still refusing to come to work um, because they want to be home when they get there. I think that's a stronger case for the employer to say, you know what, I mean, there's really no reason for you not to be at work because you have access to childcare and you have children in school and you don't need to be with them all day. And that's really kind of back to normal where, people make arrangements to pick up their children in the morning and the afternoon. And some employers have flex hours and there's ways to work around that. But um, a flat out refusal um, is probably in that type of situation suspect. Now, again, I don't know if people are refusing to send their kids to school or refusing to send their kids to daycare because they don't think it's safe. Now, again, that's a more difficult question because I imagine there'll be a lot of people who will do that. And what's the benchmark? Um, what we can't be ordered to send our children back to school. A lot of people may refuse and say, no, I'm going to stay at home and I'll have childcare and I'll homeschool my kids till I feel safe. And again, I don't know There's no precedent for that. So I can't tell you with complete confidence. I might have a problem with that. I can understand my employer is frustrated by that. But there's nothing that I'm aware of, either by way of case law or by way of statute that says if a parent does that, they're either on side or off side with the act. Okay, these are all measures that the government has instituted rapidly to try and accommodate everybody. And the government's still working through these. We've extended the wage subsidy. They're still working out the terms. Nobody really knows exactly how this is all going to play out. And there will be litigation weeks and months from now about these issues, and we'll get some guidance from courts and tribunals. But it's also new now. I can't see for certain how it's going to play out one way or the other. Okay. 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 Uh, Someone's angry at me here. The SERB says you only qualify if your childcare facility is closed. Well, that's okay. So if your childcare facility is closed, then you don't have the SERB, then you'll probably want to go back to work because you wouldn't qualify for benefits. No, of course, the sort of someone was just saying they're very frustrated with the uncertainty. Yeah, it's incredibly frustrating. And I've had many conversations um, with lots of employers. And look, it's frustrating for we're an employer. And as lawyers, we're frustrated because the rules seem to change every day. And I think we lawyers, for one, are always we're wedded to certainty, and we want to know everything, and we want it to be clear. And some things are easy to understand. The layoff rules are fairly, in some respects, fairly straightforward. But the reality for all of us and all of you listening today is that things are going to continue to change week by week by week, and sometimes in drastic ways. I mean, look, the government cannot continue paying, in my view, cannot continue to pay benefits like this forever. Um, Something's going to have to give at some point, and more big decisions are coming. And um, I just think that it's a period of overwhelming and tremendous uncertainty, and I think it's going to last for a while. And I talk about this with a lot of clients too, that the definition of crisis is a loss of control, right? What's crippling a lot of us right now, what must be causing all of us to lose sleep at night, myself included, is a loss of control. The rhythm and routine of our daily lives has been completely thrown out the window. And everything that we've grown accustomed to as parents and employers and business owners has been massively disrupted. And the worst part about it is we don't know where we're going to be in a week or 2 weeks. We just don't know. And we're trying to hang on to something, some constant, so we can provide ourselves with peace of mind. And I know it seems overwhelming, but taking control of the little things like your business, these types of conversations where we can acknowledge the uncertainty and work through it, and talking about the SERB and childcare centers are closed, true, but some might elect not to take benefits and just not go to work. Maybe they have savings, maybe they have another spouse who works and they don't need to. People were going to find creative ways to try and avoid situations that they find uncomfortable. And there will be no clear answers. And it take a long time for the courts to figure this stuff out. And it's very frustrating. I feel all of the pain that employers are experiencing right now myself. I can only imagine what people are going through right now. I have a question from Cassidy. Are the ESA rules going to change drastically? If so, do I need to change all my policies to reflect that? I think, I don't know for a fact that employment standards legislation across all provinces is going to change um, drastically. I imagine that things will continue to change organically and iteratively. Okay, we have the job protected leave under provincial legislation right now that will carry on for as long as the government decides it needs to. And there will be more changes, no doubt. I mean, the big question that all of us are asking is what permanent changes, if any, are going to be made to health and safety legislation to accommodate the safety requirements that are going to be necessary to ensure employer safety going forward. And where does that leave us in 6 months or a year? And how do we enforce those? And where do we get all the PPE that we're going to require? And what if we can't find any? And how do we enforce social distancing in an office? And where's the line? Am I going to get in trouble with an employer if people are 1.6 meters apart as opposed to 2 meters apart, and et cetera, et cetera? And at some point, um, paranoia um, and the strictness of these requirements are going to have to give way to practicality, and things will just start to open up because they have to. I really think that's going to happen. I don't know when, but this is a moving target. There will be um, more changes to come, and we might be running in one direction one week and another direction another week. And I think all of us, as best we can, as business owners, need to be prepared for that. Work closely with our advisors who can keep us in the loop. And look, I'm learning every day. I mean, I work long hours and I'm constantly trying to keep up with not only the needs of our business and my departments, but of where the law is going. It's a full-time job and it's not always easy and it's not always clear. And we just unfortunately kind of have to accept that right now and resort to pragmatism and common sense where the law drops off and doesn't fill in some of those voids that we're exploring right now. Okay, we have another 8 minutes to talk about whatever's on people's minds. Just trying to see if my screen's frozen here. There should be more questions coming, but um, oh, okay. Another question popped up. Sorry if there's a bit of delay there. Maybe my screen lagged. If I have staff asking to take a leave because she doesn't have childcare, her husband was off until now collecting the CERB, but he is going back to work. What reason can I use for her ROE? We are an essential service, so it's still open. Um, okay, well, if she's invoking, it sounds to me like this individual may be invoking the statutory leave benefits or statutory protected leave, I'm sorry, under I don't province here and under the Provincial Employment Standards Act. And if so, again, someone asked me this earlier today. I haven't filled out an ROE in a while, but I mean, it's obviously something somebody at Peninsula could help you with. But I mean, if you check the Fed's website, there should be an instruction on there how to complete the ROE, what code to use, and what description to put um, in the form that you or in the ROE record that you need to submit. Okay. Everyone can still see me here. I'm not sure if my uh, video conked out. I apologize if it did. Um, see if my IT team's on me. I don't know if people can still see me. I hope you can. My screen went blank there for a second, and I apologize. Not sure why that happened. Um, okay, double checking. It's going to be okay. Um, we got about four more minutes for everybody. If you have any more questions, I'm sorry if my video's not working. I can give it to you via audio. While we're still here. Okay, so this is from the same person who's asking me how to fill in the ROE, so I'm just reading through the requirements. Okay, well, when the employee refuses to come to work but is not sick or quarantined, use code A quit or code N leave of absence. So I guess it depends on what it says. Don't add comments unless absolutely necessary. Look, if the person's um, doesn't have childcare and she's husband was off, now I think this might be a case of the person then saying I can't come to work because I have childcare obligations. If they're invoking a statutory leave, job protected leave to care for their children, then I would guess use the code for leave of absence. And to the extent that there's any confusion or clarification required, then add commentary. It says avoid adding comments unless absolutely necessary. Usually, the government doesn't want people to put in the wrong code and then add a whole bunch of commentaries. So they have to filter through and figure out what it means. Okay. Um, if it's a leave of absence, which sounds like it is what it is, or that is what it is, then I would indicate as much. And if you have to add in some clarity at the bottom of the form, do so, but as quickly and as concisely as possible. Make it as clear as possible for the government. Okay, so it seems like my video is still working. That's great. Um, just looking at a couple more minutes. Um, People have any last questions or follow-up questions or concerns or comments? Um, Please feel free to ask. Okay, I have another question here. Will this employee be eligible for EI when on a leave of absence? Um, well, if in this, look, I don't know all the facts of this case. Unfortunately, I don't know what the circumstances of this employee are. If they're taking a statutory protected COVID-19 statutory protected leave and they've properly invoked that leave and they can't work because of it, then they would be um, eligible, I guess, to apply for the CERB subject to any conditions around school closures um, in the applicable area. Okay, so in Ontario, our schools are closed until September. Okay, but look, I can't, um, in that situation, I can't really comment more without knowing what the full factual circumstances are on the employee's specific circumstances. It's something that we, one of our team members could help you with and get a full factual breakdown and then look at um, what the employee's circumstances are and guide you through that. Okay. I do notice it's 1 o'clock and I'm just cognizant of time. An hour goes by quick. If anybody has any final questions they want to throw across the screen before we end today's session, um, happy to address those. Um, and I'll sort of keep us live here for another minute or two, and then we'll get on with our respective days. Okay, well, I think look, it's 1:01 Ontario time. So I think those are all the questions I had for today. I hope everyone has a great week. And again, if you have any follow-up questions, please do not be shy and reach out to us at info@peninsula-ca.com or go to our website where we have a COVID-19 toolkit that you can take a look at and additional information about our services and what we do. And again, have a lovely week. Thank you for joining us, and we'll see you next Wednesday. Take care. Bye bye.